articles of association can be altered as you wish to an extent. There are certain limitations on how you can alter your articles of association and certain formalities that need to be met, for example, unanimous consent or a specific procedure to be followed. So in this video, we will be discussing the limitations regarding alteration of articles of association. If you're new, let me very quickly introduce myself. I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Zoppi, my law firm. And on YouTube, my goal is to make business law easy. Make sure to stay until the end of the video to find out how to properly and legally alter your articles of association. Amazing, let's jump straight into it. Now, the Companies Act has three main limitations on the kinds of changes that can be made to the articles. Let's start with the first, which is Section 25 of the Companies Act. This section states that if you intend on altering your articles in a way that would require existing shareholders to either, number one, subscribe or buy more shares, or number two, increase their liability, then the company will need to get consent, written consent, from that specific shareholder. If any of the affected shareholders do not give their written consent, then they are not bound by those alterations. The second main limitation under the Companies Act is associated but very different. This is under Section 630, and this section states that if you intend via your alterations to vary the rights of a specific class of shares or to remove rights from that class of shares, then you will need at least 75% of that class of shares to be in favor of that alteration. And the third and final limitation that we will be discussing in this video is found in Section 22 of the Companies Act. This section deals with entrenched provisions. So these are provisions in the Articles of Association that make it very, very hard to amend. So in practical terms, a special resolution is 75%. So if a specific provision in the article states that you need more than 80% of the shareholders to be in favor, then that would be recognized as an entrenched provision. There are two main ways to make sure that you legally and validly include entrenched provisions in your articles of association. Option number one is to include your entrenched provisions in the bespoke articles of association that you adopt upon incorporation of your company. So that means that the very first articles of your company are the articles that already include that entrenched provision. If that isn't the case for you, then you'll need to opt for option 2, which is to get unanimous consent of all of the shareholders for that alteration to the articles. Amazing. Now, on the topic of altering your articles of association, there is a specific procedure that needs to be followed to comply with the Companies Act. But before we get that, make sure to subscribe to the channel to continue to receive to the point, practical and pragmatic legal information and templates. Also, on the topic of templates, I've linked below a free guide and all of the templates that you need to properly amend your articles of association. So what is the process for amending or altering your articles? Number one, you need to have a board meeting of the directors of the company. The directors need to approve the alterations to the articles. Then you'll move on to a special resolution by the shareholders of the company, unless you are, for example, doing entrenched provisions where you need unanimous consent. And finally, you will need to file documents at Companies House, for example, your resolution and your amended articles of association. If you want to watch a step-by-step walkthrough of exactly how to alter your articles of association, make sure to watch this video right here. Thank you for watching.